Hey, this is Drew Page. Welcome to the Drew Page channel. In this video, we're going to talk about the case that the United States Supreme Court just dropped today on firearm rights and the ability to conceal carry in public. So if you find this video helpful, please subscribe to the channel, like the video, hit the notification bell, and all that good stuff. So let's just jump into the meat of this. So the United States Supreme Court has taken a position on New York's concealed carry law. And what happened is New York law requires that in order for a person to conceal carry, they are to have a license. And that's whether you're concealed carrying inside or outside of buildings, homes, or whatever. And in order for you to be able to move freely outside with a concealed carry firearm and get an unrestricted license, which means that you can carry anywhere, you have to show what they define as a proper cause. And the proper cause could not be something that was just a general self-defense that anyone else in the community had, because in New York's mind, they are able to provide safety through the police, and the people don't need that kind of generalized safety. So unless there was some specific, detailed reason beyond just mere self-defense, then they wouldn't be able to get a unrestricted license to conceal carry outside of their residences. So there were two petitioners who tried to get a concealed carry license, and they were doing it based on their general desire for self-defense in the community. And they were denied the unrestricted license because presumably, according to the court's opinion, they did not have any proper cause for seeking that unrestricted license. So they took the matter to district court. District court sided with the state. The appeals court affirmed the district court, and the parties appealed to the U.S. Supreme Court. And the U.S. Supreme Court rules in favor of the gun owners and those who are seeking to get a concealed carry unrestricted license for purposes of self-defense. They note that the Court of Appeals had adopted something beyond the Heller rule, and Heller is the seminal case regarding self-defense rights and being able to carry concealed weapons, and oddly enough, out of New York as well. But in Heller, the constitutional right, the Second Amendment, was incorporated to what was made applicable to the District of Columbia, and in that case, it was essentially noted that there was no limitation for the ability of a person to carry a firearm for purposes of self-defense. And that's kind of too generalized a statement. There are obviously exceptions that are mentioned in Heller, certain types of assault rifles and other things of that nature, but we'll deal with that another time. But for purposes of this case, simply carrying a concealed weapon for purposes of self-defense does not require one to show that there is some substantially related legitimate end. It kind of like an intermediate scrutiny test, and that's what this Court of Appeals was doing, is what test should be used in order to determine what the rights are of citizens to be able to carry concealed weapons unfettered from the government. And essentially the New York District Court, and then the Circuit Court of Appeals within New York had determined that there was this test that fits something like an intermediate scrutiny, which says that the statute is substantially related to an important government interest. And while that may be something that is true, that's not the test that the U.S. Supreme Court says applies to concealed carry. They say that they look to the history of the Second Amendment in light of Heller and say that self-defense is a clear historical reason why someone should be able to carry a concealed weapon without restriction, as long as they are otherwise law-abiding. So again, they don't touch on the issue, or they don't reverse on the issue that felons should be able to do that. Those who have other kind of criminal issues, that they make a point to note that the two petitioners that are named here are law-abiding citizens, and there's no reason for them not to be able to allow them to conceal carry and not have to give some proper cause beyond general self-defense. So it's about a 135-page opinion, but again, it's another step in favor of gun rights and having citizens being able to be protected by themselves rather than having to depend on the government to protect themselves. So what do you think? I mean, with all of the different mass shootings lately and all of those things, what do you think about this ruling? What do you think that the Supreme Court should be restricting, or do you think that maybe the people should do some sort of constitutional amendment? I mean, for my legal analysis and my legal opinion on this, the Second Amendment is pretty broad. I mean, until there's a constitutional amendment to change the Second Amendment, if there ever is, I don't see any way that a court can continue to believe that they have the right to limit certain aspects of gun rights. And until that changes, unless there's a constitutional amendment that changes the Second Amendment, I think that legally those who are anti-gun are going to have a difficult road. Obviously, if there are changes in the U.S. Supreme Court, you may get people who have a different interpretation and different judicial philosophy. But at least as it stands right now, it looks to me like those in favor of gun rights are going to have the upper hand in the U.S. Supreme Court. So anyway, hope you found this video helpful. Please subscribe to the channel, like the video, hit the notification bell, and until next time, stay tuned.